You are listening to Based in Fact, a true crime podcast. Join hosts Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 3 of Based in Fact, a true crime podcast. I'm your host, Lisa O'Brien, and I'm joined today by Representative-elect Mitch Little of Texas House District 65. Mitch is a native Texan who attended Harvard University, where he graduated with honors in government and played football for the Crimson for 4 years. In 2003, he earned his law degree from the University of Texas, and he's a successful business attorney. Mitch has fought for private property rights, represented victims of securities fraud, and helped entrepreneurs build companies in numerous industries, including real estate and oil and gas. Mitch and his wife Kelly are proud parents to Molly, Matthew, and Lucy, and they're all active members of Sojourn Church in Carrollton. This is episode 16, State of Texas versus Robert Leslie Roberson III. Since 2016, Roberson's post-conviction attorneys and advocates, who were recently joined by Texas legislators, have engaged in a campaign of disinformation with the courts and the public in which they claim that Roberson's conviction rests on a diagnosis of shaken baby syndrome, abusive head trauma. Legislators issued a last-minute subpoena commanding Roberson's appearance before their committee on October 24, 2024, and with a last-minute stay by the Texas Supreme Court, they were able to prevent his sentence from being carried out on October 17, 2024. Representative-elect Little joins me today to talk about the facts of the case, the truth about Nikki's cause of death, and the court proceedings and extrajudicial shenanigans of Roberson's advocates. And good afternoon and welcome, Representative Little.
Very glad to be with you. Thank you, Lisa.
So I met you informally through a post you posted on X, which provided a overview of the actual facts of the cause of death for Nikki Michelle Curtis, who was killed by her father, Robert Roberson. So why don't we just start in, how did you become aware of the case and get involved and get to the point where you were posting on X in the middle of a House of Representatives campaign for the state house in Texas?
Well, Lisa, I think like a lot of people, I saw what was going on in the Texas House and I got mad, I think is the right word for it. I was definitely irritated by the fact that all this advocacy was going on in the House from both the Democrat side of the House and the Republican side. And the narrative or the dialogue that was going on around Roberson's conviction and his upcoming execution was all coming from one side. And what I was finding was it was very difficult to get a different view on the facts and the evidence of the case. And so I kind of started doing my own research and found out that there was a lot more to this story than the anti-death penalty advocates were letting on, and certainly than was being discussed in the House Criminal Jurisprudence Committee.
So that is, and I call it shenanigans because what I really want to call it is probably a bad word.
Well, it's really what it is, Lisa, is it's an appeal to emotion. So what was going on is these elected officials from the Texas House, they made trips to Huntsville. They talked to Roberson about his day-to-day life, the fact that he's doing Bible studies in prison. They hear his side of the story. They all take friendly, smiling pictures. They get information spoon-fed to them by his appellate counsel, and you never really hear the other side of the story, which is what happened to the victim in this case and the evidence that was adduced at trial. So the appeal to emotion is primarily, I think, it's the best tool that the anti-death penalty advocates have in the Texas House. They say, well, look at this guy. Hear his story. Here's another look at it. Here's another possible explanation for Nikki Curtis's death. And it's really unfair argumentation because you don't have the people with the facts pushing back. Nobody ever really looks at the transcript. Nobody ever digs into the facts. And that was what I decided to do. I wanted to know for myself what happened based on the witnesses and the evidence that was adduced at trial, because, as lawyers, that's what matters.
Mm-hmm. And Jeff Leach, who's a lawyer, should know that.
Yeah, I think
Moody, I think is a lawyer.
Yes. Yeah. Joe Moody is also a lawyer. I think what you're seeing is anti-death penalty advocates on the right and the left, Republican and Democrat, using individual cases as a lever to re-examine the viability of the death penalty writ large. Mm-hmm. And so if the end goal is to get rid of the death penalty, and one of the members of that committee, John Busey, has already filed that bill in Texas this year to get rid of the death penalty. If that's really the goal, then the facts of the case don't really matter. We in order to get to the goal, we'll use whatever information or whatever tactics we have to get there. That to me is what is troubling as a lawyer.
Right. And they're only, basically they're just copying the Oklahoma people, Kevin McDougal and Justin Humphrey, and those people who started advocating for Richard Glossop.
Yeah, there's a template. There's a template, and they overlay the template on pretty much any set of facts to say, these people are innocent, when in many cases they didn't even argue their actual innocence in the underlying trial.
Mm-hmm. Or when they did, it just didn't work, which is what happened with Roberson. But we're spoiler alert.
Yeah, it didn't work. It didn't go so well.
Yeah.
But you look at the Roberson case, his lawyers, neither in opening or closing, asked the jury to find that he was innocent of the charges. They argued the mens rea. They argued that there were lesser includeds they could find him guilty of, but no one said that anything caused Nikki Curtis's death other than Robert Roberson.
Mm-hmm. All right, so let's go. Our usual format is we talk about the victim, and unfortunately, in this case, Nikki Michelle Curtis Bowman, her life was cut short. She was born October 20th, 1999 in Fort Worth, Tarrant County, Texas. And interestingly enough, Innocence Project and Gretchen Sween, nobody wished her a happy birthday.
They rarely do. It's just it's a means to an end.
Her parents are Robert Leslie Roberson III, and Gwendolyn Michelle Bowman. She has half brothers Christopher Hamby and Matthew Bowman, and then Robert Roberson Jr. and Victoria Roberson, who were Roberson's children from his first marriage. Her grandparents were Robert Leslie Roberson Jr., who died in 2012, and Carolyn Roberson, who may have passed away in 2021. And then Larry Bowman and Verna Bowman, who were her mother's parents. And her cause of death, contrary to what has been claimed, was blunt force trauma to the head. Robert Leslie.
And there should be no dispute about that based on the evidence that was submitted at trial.
Correct. Well, they have, I think they've said, she had some sort of clotting disorder, and she had been given Phenogran, and she had been given medications with codeine that they no longer give toddlers. But yeah, based on what the treating physician saw when they treated her in the hospital and what the medical examiner saw, blunt force trauma was her cause of death.
Based on what every single person who handled her lifeless body said, including every nurse and every doctor and every medical examiner who testified at trial.
Correct. And these other doctors who looked at her medical records, who basically went back to the beginning of her life and parsed out anything that they could say was some disease process that would lead to her dying 2 years later.
Yeah, certainly there's the pneumonia theory.
Yeah. And then the other thing, like they're saying she has some kind of clotting disorder, and that's what led to the bleeding in her brain, even though there was no trauma.
Yeah, I've definitely heard that. I've heard that alleged.
So, all right, her killer, Robert Leslie Roberson III, he was born November 10th, 1966 in Wood County, Texas. His parents were Robert Leslie Roberson and Carolyn Roberson. He has siblings, Ramona, Diana, Deborah, John Patrick, Billy Leroy, Thomas, and James. He was married to Della Gray. They were divorced. He had Teddy Cox was his living girlfriend at the time of Nikki's murder. He has children, Robert Jr., Victoria, and Nikki Michelle Curtis Bowman. And I want to clear up something else right now. He did not step up when he realized he was Nikki's father. His mother somehow realized that he might be Nikki's father and pushed him to assert and prove paternity.
Yeah, I believe
and then
I believe
she
that's
pushed
the
him
case.
to take custody.
Yeah. It's just a very, I mean, there are many stories like this going on in Texas on any given day. I believe Nikki's mother was a drug addict and I believe incarcerated as well. And Nikki needed someone to care for her. And Roberson being her actual birth father, at some point tested for paternity, and he and his girlfriend Teddy took over custody of her.
But there was also many people testified that they didn't want Nikki alone with Roberson.
In fact, my understanding, Lisa, is that the night of Nikki's death was the only time Nikki had ever been alone with Roberson as her sole caregiver.
Right. And he had only had custody ever since November of 2021. November of 2001.
Yes.
And this is 2 months later. So
it had not been a long time.
Yeah. That she ended up with him was a fluke that really in the long run should never have happened.
It shouldn't have. It was a perfect set of circumstances. So Teddy was in the hospital recovering from surgery, and Teddy's mother, I believe her name was Ms. Bowman, she came down. She was supposed to take care of Nikki that night, and Nikki was going to spend the night, but Ms. Bowman herself had come down ill, and so Robert had to go and pick her up.
Nikki's maternal grandmother.
Yes.
Teddy Cox's mother was elsewhere, but she was caring for Teddy's daughter Rachel.
Right.
Because Teddy's daughter Rachel could not be left alone with Roberson.
Right.
So, and that is, he was abusive. There were sexual abuse allegations, and just because he wasn't arrested and charged and convicted doesn't mean those things didn't happen.
We don't know. We don't know.
So there's a lot of claims like, well, they didn't pursue them. No, of course they didn't pursue him. They had him on capital murder. They didn't need to pursue him on sexual abuse of his daughter, Rachel, or anyone else. So,
he had been charged with sexual abuse of Nikki, and as the trial began, the state ultimately did not adduce enough evidence to proceed to the jury, and so those charges were dismissed at trial.
Correct. But like I said, just because it doesn't mean the event didn't occur. And it's Roberson's own admission to it. And that's another play. That's another play in their book or their playbook is, well, let's go through and let's say how horrible all the witnesses were. So they were all lying. Sure. And let's take and parse their words from one statement to the trial testimony, and that supposedly will prove they're lying. So, but yeah, that doesn't mean it didn't happen. And that's another thing that really annoys me to no end.
No doubt.
So, and I just want to add one thing on here. After Nikki died and Roberson was arrested, he was asked point blank by Teddy Cox whether he killed Nikki. He said that if he did do it, he don't remember that he snapped, and he don't remember doing it.
Yeah, we've heard. He actually told multiple people multiple different things after she arrived at the hospital. But I think that's probably the most egregious when Teddy was visiting with him.
Yeah.
He said, if I did it, kind of the OJ book, if I did it. Well, the problem is there's no other reasonable explanation for what happened to her.
Right. All right. So Roberson was arrested on February 1st, 2002, when Nikki died. And there's been much made about the fact that he was not consulted when the decision was made to turn off her life support.
Yeah, I've heard that.
It was the Bowmans were the ones in the hospital with her. He wasn't there. Right. Because he was arrested. But, really, theoretically, if you're accused of causing injury to somebody, people are not going to want you to have control over life or death for them.
Yeah, that's right.
Either because you're going to prolong their life, or
it creates this perverse incentive for her not to die so that he can never be charged with murder. When she was clearly brain dead from uncle herniation of her brain.
Correct. And that doesn't happen from pneumonia.
Definitely not.
So her autopsy was conducted on the 2nd of February. The report was not issued until April 2nd, 2002, which means that Dr. Urban presented her findings to a panel of other medical examiners in the Dallas County Medical Examiner's Office, and they all signed off.
My understanding is they do that on every homicide case, that it's essentially it's like rounds, that you'll have a series of doctors who will sign off on the findings, so that there really isn't any meaningful doubt. That correct. You look at you have multiple medical professionals looking at the data to make the determination whether it's reasonable. You don't want a rogue medical examiner taking matters into their own hands, or standing alone on something as significant as capital murder of a child.
Correct. And I want to just also point out that it is horribly unrealistic to expect a medical examiner to get every hospital and medical record in existence for anybody, regardless of their age, just to eliminate non-homicidal means, manner, or causes of death.
Sure.
Which is what that is the primary criticism of Dr. Urban from Roberson's advocates, is that she didn't get Nikki's medical records and get the big picture of what a sick child Nikki was.
This is an interesting point that's made by the advocacy groups, that she didn't have all the information. Well, one of the physicians who actually received her into the emergency room had seen this little girl 2 days earlier and was shocked that she was back, because when he left her, he said she was in good shape. The girl was fine. Like the emergency room doctor was questioning himself whether something had been missed, perhaps. But then he examined her, and it became readily obvious what had happened to this child.
Correct. So in a way, she would have had that, because she would have had access. And it's not necessarily, she doesn't necessarily have to do that, because she deals with what is presented to her in the morgue and at autopsy.
Yeah, that's right.
Now,
She had seen her after other physicians and treating nurses had seen her.
yeah. And because of all the allegations that the information put forth by Ken Paxton is false or somehow misleading, based on the autopsy report, I'm going to go through the findings that show that there was no even thought of shaken baby on the part of Dr. Urban at the time of Nikki's autopsy.
Yep. And well, I think it's very important for your listeners to understand that when Dr. Urban testified, and I have a copy of the trial transcript, when she testified, it was referred to as shaken impact syndrome. So when you have a child that is essentially beaten to death, it's not normally from punches to the face, although it could be. It's a series of events that typically result in a series of blunt impacts, and also to include shaking. But if you look at Dr. Urban's conclusions, there is no doubt that Nikki died from blunt impact.
Right.
It may have come in concert with having been shaken, but there is no doubt that there was serious head trauma that had been caused by a blunt impact.
Correct. And I'm just going to go over evidence of injury, blunt force injuries, head and neck, faint 2 by 1.5 inch yellow-brown contusion, 1/4 inch abrasion lateral to the left eye, 1/4 inch blue contusion to the left side of the cheek, 2.5 by 1.5 inch aggregate of blue-purple contusions on the posterior scalp, laceration of the upper frenulum, and 2 1/4 inch blue contusions on the chin. Now, this is a few days after her admission to the hospital, so these would have been bruises that were in the process of healing. These were also observed by the medical personnel who treated Nikki at the emergency room in Palestine, as well as in the hospital in Dallas. There was a quarter.
There's no doubt. There's no doubt that. So if you read the trial transcript, the very first nurse to testify, who was the first nurse to have examined Nikki in the emergency room, made it clear that as they were examining this child that was essentially not breathing, coding, etc., as she began rolling Nikki around, looking at her, she is the one who first observed the bruises on Nikki's face. And they were fresh and they were forming as they were treating her.
Right.
And so the nurse is the first person to have said, there's something, and I believe the quote was from the trial transcript, there's something else going on here. And they ultimately went out to interview or talk to Roberson about what had happened.
Yeah. And on Nikki's trunk, they had a 1.5 by 1 inch aggregate of red-purple contusions with some scattered yellow-green discoloration on the posterior right upper shoulder. And then on her extremities, a 1/4 inch abrasion on the left lower arm and a 1/4 inch abrasion on the left side of the foot. Her findings were blunt force injuries, diffuse subscapular and subgaleal hemorrhage with discrete foci subgaleal hemorrhage of the vertex of the scalp, occipital region, and left temporal region. So these are different parts of the head that have hemorrhage.
Different blunt impacts. If you read the trial transcript, the doctors, including Dr. Thomas Conjoyan, so the doctors who treated her in the ER and the doctors who tried to treat her in Dallas and the medical examiner all made the same observation that they call mushiness or bogginess at the back of her scalp, that consistent with a serious blunt impact. So when you hear the Innocence Project and her appellate lawyers say, well, she didn't have any skull fractures, there couldn't have been a blunt impact, there don't need to be skull fractures in order for her
Yeah.
to be brain dead. And
that's one of their fallacies.
it's one of the fallacies. It's kind of what you would call a false dichotomy. Either she has a broken skull, there are skull fractures, or something else other than blunt impact killed her. Well,
Right.
the swelling, which was substantial, what's called subscapular hematoma, observed by all these doctors and the medical examiners, made it clear that there had been a series of blunt impacts that could have been consistent with, I don't know, banging her head against the floor, banging her head against a mattress or bed. We don't know. What we do know is she came in there and had obvious signs of blunt force trauma to her head.
Right. And the only adult was Roberson.
The only person with her, save and except for Roberson's explanation that there may have been someone else with him that night.
Yeah. Who did everything he claims he didn't do.
Well, he's made a series of claims. Yeah, he's made a series of claims about that.
So, and then she had subarachnoid and subdural hemorrhage, cerebral edema with bilateral cerebral infarcts, traumatic axonal injury, bilateral perineural and retinal hemorrhage of the eyes, hemorrhage into musculature of the back, contusions of the head, lip, and left shoulder, laceration of the frenulum, abrasions of face and extremities. And the frenulum is the little tag of skin between your lip and your gums. And I think you have one at the top and at the bottom. And
yeah, that's right. And it had been torn. It had been torn, and one of the explanations that you will hear from Roberson's appellate counsel was this is consistent with intubation, them putting a tube down her throat to help her to breathe. All of the physicians and the medical examiners will tell you, no, that is not something that happens, and that a torn frenulum is consistent with a strike to the mouth.
And the torn frenulum was observed before intubation, not after. So because it was, the nurses testified to it as well.
I don't think there should be any doubt about that.
So, all right. Again, it's a false premise that they present that is so maddening. And it's like whack-a-mole, because every time you knock one down, they come up with a new one.
Yes.
So
there have been a series of defenses presented. The appellate counsel has now said, well, we admit that she fell off the bed that night, but I mean, the physicians who testified at trial made it consistent that, or consistently testified that Nikki's injuries were not consistent with a fall off the bed.
Correct, because that a fall off the bed like that would not cause these multiple injuries. It could cause one or two, but not this many.
No, certainly not.
Roberson was indicted on April 25th, 2002, capital murder for death of a child under 6 and capital murder for death occurring during a sexual assault or attempt to commit a sexual assault. He went to trial in the 3rd Judicial District Court in Anderson County, Texas, before the Honorable Bascom Bentley III. His counsel were John Van Meter and Steve Evans. Texas has the strangest trial procedures in criminal cases. You apparently select your jury during September and you go through voir dire, but then you don't actually seat your jury until December, because his jury was not seated until December 28th. And then you have a couple of months before you actually start your trial.
Well, one of the difficulties, and I don't think that this is consistent with criminal cases writ large, in Texas, when you have a case involving the death of a child, typically you need to order a panel of sufficient size that you can actually seat a jury. Because when you have a case that involves harm to a child, there will be a lot of potential jurors who simply cannot deal with it, or will presume guilt, or may have a series of biases or prejudices that may not make them good jurors for a case like that. So typically, they're going to have to really go out and put out the dragnet to find a sufficient number of jurors to potentially hear the evidence in the case.
And I've seen this in a couple of other Texas cases where they, like they do the jury selection in March, but the trial doesn't commence until late April or early May.
Yeah, I think it's most unusual, and I think it has to do generally with the type of case and the subject
Oh,
matter involved.
okay. I'll take that. So, the guilt innocence phase of Roberson's trial was conducted between February 3rd to February 11th, 2003. The jury rendered its verdict on February 11th, finding him guilty of capital murder of a child under 6. The penalty phase then went forward from the 11th until the 14th, and the jury ultimately sentenced him to death. A formal judgment on that was signed on February 19th, 2003, and that was entered by the judge. Roberson did file a motion for new trial on March 7th, 2003. I didn't find anything, but we can all presume that was denied.
No. Yeah.
Then he proceeded to direct appeal. He was represented still by Stephen Evans. He raised multiple issues, all dealing with the jury instructions and the death penalty, challenging the death penalty in Texas and capital murder statutes, specifically the death of a child under 6. And he did raise sufficiency of the evidence claims in two of his issues, points of error. Oral argument was held on November 17, 2004, and then he also had a state post-conviction process that was parallel to his direct appeal. He filed that application on December 13th. Again, he raised a lot of issues related to the death penalty and sufficiency of the evidence and mitigation issues, and alleging some trial error as far as evidence went. None of it was Nikki's cause of death or shaken baby. That appeal or that post-conviction claim went forward on July 20th, 2005. Roberson pro se filed a notice of desire to raise additional habeas corpus claims. And in those, he raised ineffective assistance of trial counsel because his attorneys failed to investigate and represent me in the standards set forth by the Bar Association and law. His attorneys failed to raise and challenge the issue of distress in my case. I was threatened to participate. My attorneys or habeas counsel could have talked to and investigated Heather Berryhill. I was threatened by this woman if I testified against her. My family's life was threatened as well. These are Roberson's own words, which is interesting because he's supposedly on the spectrum and unable to really relate to things the way others will. So I find this quite interesting that he actually files this with the Court of Criminal Appeals.
Yeah, it's very odd. It's very odd. There have been, a number of, there's been a lot of issues raised about his mental state or psychological state, and whether he's capable of holding a conversation, whether he's, can have a conversation over Zoom. Example, one of the things that came up in the Texas House was, oh no, we need to have him physically here because he's autistic. He won't be able to, I guess, read the room over Zoom. He won't be able to interact normally over Zoom.
Yeah. Well, that was also, there were two different stories on that one. That was one from the legislators, but Gretchen Sweem also said she wasn't going to allow him to participate via Zoom.
Yeah.
So, and then he also alleged that they failed to talked to Heather Berryhill and failed to investigate her after he notified habeas counsel to do so. And he failed to challenge, he says his counsel failed to challenge the way the death penalty is given out because I do not have any other priors or any cases other than the things brought forth during trial.
Yeah.
And then he, this is where he starts alleging actual innocence and trying to blame someone else. The trial court went through his his post-conviction claims and issued findings of fact. And one of the issues he was raising in his main claim was that his jail cell was apparently searched and evidence that was never used was seized.
I don't even know what it was. Do you know what the evidence was that was
No,
supposed
I
to?
don't know.
Okay.
Although I think it had something to do with the admission of sexual abuse of Nikki.
Sure.
To the cellmate or cellmate or fellow inmate.
Yeah, I had heard about that. That the Office of the Attorney General in Texas had made a statement about an admission by Roberson to a cellmate or someone else, a jailhouse confession to sexual assault of Nikki, something along those lines. But as far as I know, that had no bearing on whether he murdered her.
Correct. And so basically, the trial court found that he had waived any complaint regarding the search of his jail cell when he agreed before the court that the matter would be resolved by a stipulation that the state would not use any evidence obtained in that search. Additionally, he made no further objection and was not denied further relief by the court. The claim is also procedurally barred because it could have been raised on direct appeal but was not. An applicant has failed to assert any new facts which, if true, would entitle him to relief. And then finally, the court found while the defendant is incarcerated, he has no expectation of privacy in the jail cell or the clothing he wears within the cell.
Yeah.
So, and that's one of those other things that really, it's making a mountain out of a molehill.
It just has no bearing on the outcome of the case, as do
Because
many other
it
things that
doesn't
have
have
been
any
raised.
bearing on guilt or innocence, certainly.
Certainly not.
And then most of the other claims either were procedurally barred because they could have been raised sooner and weren't. And this is because they're based on facts that Roberson and or his counsel knew at the time of trial.
Yeah,
or
it's
at
not
the time
new
of direct
evidence.
appeal.
Not new evidence, not new information.
Correct. It's just a new spin on that information, which is what generally happens in post-conviction. So that's, I'm not going to go through all of the findings, but he wasn't challenging the cause of death or presenting anything that sought to refute that cause of death. Then they did find on his they recommended dismissal of his subsequent claim that was filed pro se. And that was done on July 27, 2005. On March 12, 2007, Roberson mailed what is basically a pen pal request on a website called Lamp of Hope to the Court of Criminal Appeals, in which he claims that Heather Berryhill, who was Teddy Cox's sister, showed up on January 30, 2002, unexpectedly at the house, that Roberson admitted that the two smoked some crack and then had sex while Nikki was on a pallet next to the bed. Roberson claims that Nikki crying set off an argument with Heather. Then he states, while Heather and I were arguing and I couldn't get Nikki to stop crying, so I gave her to Heather and tried to get her to stop crying. I laid down on the bed because I was kind of high, or let's say my mind was altered from the drugs. I wasn't off it at first, but I must have dozed off or closed my eyes for a while. Then I could hear Nikki crying louder. It sounded kind of strange the way she was crying. So I opened my eyes, and what I had seen tripped me out. Heather was shaking Nikki back and forth from front to back. Then I asked Heather, "What are you doing?" Then she said, "I'm trying to get Nikki to stop crying some." I got onto her and Heather threw Nikki on the floor, and Nikki bounced off the floor, hitting the floor hard. Then I got up to check on my daughter, but Heather convinced me that Nikki was going to be all right. So I went back to go lay down on the bed. But at the same time, Heather and I were arguing some more about me not giving her any more money like I had been before that night. That's when she picked up my precious little sweet angel Nikki again and started shaking her some more. Somehow during that time, she had threatened me about my life and my family's life if I told on her to the police. She said the police wouldn't believe me anyway because I had been to prison before. Me being a dummy, being scared and influenced on the drugs, had laid down and dozed off and went to sleep. I mean,
Not a lot
I'm
of discussion
sorry.
in there about pneumonia, is there?
No,
Not a lot of discussion about a clotting disorder or
not a
any of
freaking
that.
word.
Yeah,
And
and
really, I mean,
the
it's not even
people
reasonable.
the people
It
of Texas should be uh, angry that the House Criminal Jurisprudence Committee is spending taxpayer dollars advocating on behalf of this man. And
mhm,
you bring up this pen pal request. This is not something that is really within the public purview yet, because the committee hasn't talked about it. You haven't seen Dr. Phil talking about it. Dr. Phil has since taken up Robert Roberson's innocence effort, as has the author John Grisham.
mhm,
And you'll notice that the detective who investigated the case in the Palestine Police Department, and has now become a pastor and has decided that Roberson is innocent, as has one of the jurors from the case who testified before the House Criminal Jurisprudence Committee. But nobody ever seems to talk about this,
mhm.
that Roberson himself, by his own hand, wrote to the Court of Appeals and said, there's an alternate killer. Here's what really happened. And um, nobody's ever asked to tie off that loose end.
Mhm.
There are plenty of appellate lawyer explanations for how Nikki could have died that night, but none of them ever touch on this.
I suspect that if you put Gretchen's feet to the fire, what she will say is he's autistic. He doesn't know what he's doing.
I'm
It
sure that
doesn't mean
I'm
anything.
sure a lot of your listeners have autistic people in their lives, okay,
Mhm.
or maybe even family members or friends. But I think it is demeaning to suggest that autistic people, by psychological necessity, lie about who committed murders in
Mhm.
order to explain things that didn't happen. I I think that is unnecessarily demeaning of autistic people. This is
Right.
someone who is trying to explain what happened apparently for the first time, because he didn't testify at trial. He didn't tell the authorities what happened. He told the nurses and doctors in the hospital and Teddy different things about what happened. But when he puts it in his own hand years later, his explanation for what happened to this girl is not a fall off the bed. It is
Mhm.
that the woman who I was sleeping with, who I smoked crack with, murdered Nikki, and I'm
And I lied because I was afraid of her. Oh, it sounds like Mitch had a glitch. So,
I'm here.
oh, okay. You just
Yeah,
cut out for.
my wife called me.
Oh, okay, okay. All right. So the direct appeal was decided on June 20th, 2007. And basically, the court pretty much unanimously found that a jury found the appellant guilty of the capital murder of Nikki Curtis's 2-year-old daughter. The jury rendered a verdict on the issue of punishment that required the trial court to sentence the appellant to death. In the appeal to this court, which statute requires, the appellant raises 13 points of error. We find no merit in them and we affirm the judgment. Roberson filed a motion for rehearing, which was denied on October 3rd, 2007. He filed a petition for writ of certiorari to the United States Supreme Court on December 28, 2007. That was denied on April 14th, 2008. So his conviction and sentence at that point became final. So
Lisa,
in the reality, yes.
can you hear me?
Yes.
I'm hearing your music over your voice.
Oh dear.
I don't know what I'm doing wrong here.
That's not good. It's not playing for me.
Should I log out and log back in?
Yeah, why don't you do that real quick?
All right, sorry.
Yeah, we'll pause for a minute, and we're having some technical difficulties. That's the fun of a live show, is that we used to have a wonderful audio editor, Emily, we miss you, who would handle these things for us, but she went on to bigger and better things, and we wish her the best. So we will let Mitch sort his difficulties out. And as I was saying, and I'll kind of reiterate this when Mitch is back, at this point in the reality of the legal system and the criminal justice system, Roberson's conviction and sentence became final. That means the issue of his guilt or innocence is decided, and it's final. And now the burden shifts to him to prove that he is actually innocent, or that there was some error at his trial that rendered it fundamentally unfair, entitling him to a new trial. So Mitch is back, and we're going to bring him back into the studio. Hello, Mitch.
Hey, sorry about that.
That's quite all right. So I was just commenting that the issue of Roberson's guilt has been settled at this point because his conviction and sentence have become final, and that the burden now shifts to him to prove actual innocence or to prove that some fundamental error in his trial entitles him to a new trial. And that it's not the opinions of legislators and jurors.
As far as I can tell, that's all foreclosed to him now. And so it's why you're seeing kind of the hysterical machinations of the legislature trying to, and they effectively did delay his execution by subpoenaing him, obtaining a temporary restraining order from a very left-leaning Democrat judge in Travis County, which then went up to the Texas Supreme Court, who entered an appellate stay. And now the Texas Supreme Court has entered an opinion on it.
Now, that's an interesting thing, too, because they actually, the TRO was actually vacated by the Court of Criminal Appeals.
Right.
And then they appealed that more or less to the Texas Supreme Court.
That's right. So,
and that was something that is one of the things that really angered me, because the Texas Supreme Court really doesn't have jurisdiction over an execution. But I think because they had the novel procedure of the legislators being the ones driving the bus, that it worked in their favor.
It's very odd. This is a novelty for Texas jurisprudence to have the legislature essentially try to intervene in an execution in a way that will prohibit it. And their subpoena to him to testify was their attempt to prevent the execution from moving forward, which they effectively did. Now, though, we have a Supreme Court opinion on the separation of powers, making clear that this was not an appropriate use of them.
Yes, and that's we'll hopefully be able to talk about that later. So Roberson's state post conviction now continues, and that was went back to the Texas Court of Criminal Appeals, and they reviewed the record with respect to the allegations made by applicant, They adopted the trial judge's findings of fact, and based upon their findings and conclusions and their review, the relief sought was denied. They also dismissed the notice of desire to raise additional habeas corpus claims as an abuse of the writ. And that was all under 1171. Roberson moved on to federal court, where he again challenged the sufficiency of the evidence to a degree, but did not challenge or raise any issues or present any evidence regarding Nikki's cause of death. So I'm going to we're going to go through that process. He had multiple attorneys because the process took several years. It began when he filed his petition on September 14, 2010, and did not end until 2014 when findings of fact, reports and recommendation was issued on August 20th, 2014, basically denying relief. But this is what the magistrate had to say. In conclusion, Roberson has not shown that he is entitled to federal habeas corpus relief with respect to any of his claims. The petition for writ of habeas corpus is denied. In this case, it is respectfully recommended that reasonable jurists could not debate the denial of Roberson's 2254 petition on substantive or procedural grounds, nor find that the issues presented are adequate to deserve encouragement to proceed. Accordingly, it is respectfully recommended that the court find that Roberson is not entitled to a certificate of appealability as to his claims. So basically, they recommended the petition be denied and that no appeal be allowed at the Fifth Circuit Court of Appeals. Roberson filed an objection, and then the court on September 30th, 2014, the district judge filed an order of dismissal, denying his claims, denying a certificate of appealability, and adopting the report and recommendations as a whole. A final judgment entered on the same date, and Roberson appealed to the Fifth Circuit Court of Appeal. He was represented by, again, multiple attorneys, and I believe they're all pro bono. I think some of them are loosely aligned with Innocence Project. And one of them, Callie Heller, is from the Oklahoma Federal Capital Defenders Program. So that's another interesting thing in capital post-conviction, is we're finding public defenders from other states coming into either Oklahoma or Texas and handling cases in those states.
Yeah, I think there's kind of an ideological alignment, or an ideological crew that's going from place to place in, I guess, really in challenge to the death penalty as a whole, trying to find their trial balloon cases to get rid of the death penalty itself.
So Roberson filed a motion for certificate of appealability, raising issues related to violation of his rights by presenting evidence as to manner and means of murder committed during the course of a sexual assault in order to inflame the jury with knowledge that the evidence was insufficient to support conviction, that the Constitution required the state to sever the sexual assault manner and means for a separate trial, and that limitation of one of his experts' testimony violated his constitutional rights to present a complete defense. Again, nothing to do with cause of death or manner of death. His certificate of appealability on issue 3, which was the limitation of his expert's testimony, was granted, but the first two issues were denied. And then on August 10th, 2015, the circuit court issued its opinion and basically stated, given the ambiguous and equivocal nature of Dr. Cruz's opinion, which was merely that Roberson's post-concussional syndrome theoretically could have affected his formation of intent or knowledge, but that it did not necessarily do so, and that there was not any way really to tell, Dr. Cruz's testimony at sentencing does not alter our conclusion that under the deferential standard of review articulated in AEDPA, The decision of the Court of Criminal Appeal was not contrary to or an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. So they affirmed the judgment of the district court. Roberson sought rehearing. That was denied on September 9th, 2015. He filed 2 petitions for writ of certiorari to the U.S. Supreme Court. One was related to the denial of his request for appointment of new counsel during his appeal, and the second one was related to the denial of habeas relief, and both of those were denied. The first one related to counsel was December 17, 2015, and the second one was February 29, 2016. The state then moved for an order of execution, which was entered on January 5th, 2016, setting the execution for June 21st, 2016. The death warrant was issued and sent to the sheriff for service, and it was served shortly thereafter. Motion to stay the execution was filed on June 8th, 2016. And this was the first time that Roberson alleged that there was new scientific evidence establishing by a preponderance of the evidence under Article 11.073 that Robert Roberson would not have been convicted. They alleged that the state relied on false, misleading, or scientifically invalid testimony. They alleged that he was entitled to relief under Herrera because he was and ex parte Elizondo because he was actually innocent, and that he was entitled to habeas relief because his due process rights to a fundamentally fair trial were violated by the state's introduction of false forensic science testimony that current science has exposed as false. Now, for all these claims of false and misleading and testimony and forensic evidence, the reality is that Roberson's attorneys have a difference of opinion or have found experts with different opinions than those given at trial.
Yeah, one of the main axes or vectors of attack that they offer on appeal is shaken baby syndrome, is basically a discredited, worthless scientific phenomenon, and because Roberson's conviction was based on shaken baby syndrome, therefore he should be entitled to a new trial. Mm-hmm. And the problem is that his conviction wasn't based on shaken baby syndrome, but the blunt trauma that this child incurred.
Right. And that's the other thing that really makes it so maddening, is because apparently Roberson's attorneys and the legislators feel that under 11.073, they present their allegations and a court just rubber stamps them and gives everybody a new trial. Yeah, that's how they believe that 11.073 is supposed to work, apparently.
Yeah, it's very deconstructive of our legal system. And this is the part that is very difficult, I think, for Republican legislators to full-throatedly assert in the way that our Democrat legislators do. There are some people who just say, "Yeah, he's innocent. Let him go." There are others who won't go that far, mostly on the Republican side, who say he just needs a new trial. Well, there's a reason that we don't have new trials over 20 years after the events made the subject matter of the trial. Mm-hmm. That we don't have the same evidence. We don't have the same people. The distance of those memories is going to make it more difficult to prove his guilt, not less difficult. Yeah. I think that the end goal being that this person walks out of prison. I think most Texans will find that reprehensible, given Correct. The evidence that was submitted at trial.
So on the same date, Roberson filed a subsequent application alleging the same grounds for relief. Now, the Court of Criminal Appeals did find that those grounds had some merit, and on June 16, 2016, they issued an order saying, after reviewing applicant's application, we find that his claims satisfy the requirements of Article 11.071, Section 5. Accordingly, we remand those claims to the trial court for resolution. Applicant's motion to stay his execution is granted pending resolution of this application. Applicant's motion for leave to file appendices 1, 2, and 4 under seal is also granted. And this is where they're presenting Nikki's medical records that allegedly support the pneumonia. Cause of death is pneumonia.
Right.
Now, the state obtained, or the OAG, on November 18, 2016, a signed statement or notarized statement from Jill Urban, MD, the medical examiner who performed the autopsy, in which she stated the autopsy findings are all consistent with blunt impact. The facial contusions are evidence of blunt impact. The multiple discrete foci of subscapular subgaleal hematomas are consistent with impact sites. While I did explain the theoretical mechanism of shaking causing injuries in this case, I quite clearly defined multiple impact sites to the head and ruled that the death was due to blunt force injuries. I also provided a list of possible reasons a lethal head impact would not result in a skull fracture. At no point did I indicate that the decedent had a triad of symptoms, retinal hemorrhages, subdural hematoma, and cerebral edema, that indicate shaken baby syndrome, or that the lack of skull fractures was indicative of shaken baby syndrome. A short fall should result in a single impact rather than the multiple discrete impact sites seen upon reflection of the scalp in this case. It was my testimony that multiple impact sites were identified at the time of autopsy and that this child died as a result of the blunt force head injuries. While I was asked on the witness stand to describe the mechanism of shaking, my testimony was that I could definitively identify impact sites at autopsy. While I could not rule out a shaking component, I relied on in my autopsy. I ruled in my autopsy that the death was a result of blunt force head injuries and emphasized head injuries in my testimony. Now, there was an evidentiary hearing held by the trial court, and this was not a quick process. They had one session on August 14th, 2018. They had openings and they had some witness presentation, and then they adjourned the hearing to be continued at a later date. And then between March 2020 and March 2021, we had COVID-19 and we had the shutdowns, and so the court was unable to schedule, apparently unable to schedule in 2019 and unable to schedule in 2020 through 2021. But on March 9th, the evidentiary hearing resumed. It was held from March 9th to March 12th, and then from March 15th to March 19th. So that's about 2 weeks of hearing time. And they completed the hearing. So
it's longer than the entire trial took.
Correct. And Roberson got to present all of his evidence and all of his argument and all of his and his attorneys have posted those records. And they've posted not only the records but the pleadings. So it wasn't a rubber stamp of denied to Roberson's claims as they're pretending it was now.
Yeah, there has been no shortage of opportunity to adduce all of these facts and all these ideas and opinions and testimony that should entitle him to a new trial. Every court possible has heard all of these contentions.
Mm-hmm. So the Court of Criminal Appeals on January 13th, 2021, they kind of started wondering, well, what the heck happened with Roberson's case? Because we haven't heard anything in a long time. They issued an order giving the trial court 45 days to complete this process. Then they received motions from the trial court citing discovery issues and pandemic-related delays. And the trial court requested an extension until September of 2021, which was granted. The trial court filed a motion for additional extension of time on July 27, 2021, which was granted on August 25th, 2021. And on December 13th, 2021, the Court of Criminal Appeals granted yet another extension and sought to have everything done by February 15th, 2022. The court held a hearing on January 31st, 2022, and I'm sorry I missed that in my notes to you. And that was where closing arguments were held. So they got to come in, they got to give their closing. And then the court issued its finding of fact and conclusions of law on February 14th, 2022. And basically, the findings are very long and very involved. But essentially, they found that Roberson's expert's testimony did not clearly prove that Nikki's cause of death was shaken baby or anything other than blunt force impact. Also, the court found that SBSH, which is the shaken baby syndrome abusive head trauma, is still an accepted mechanic of death. It's also accepted by the American Pediatric Association. And that Roberson's own expert, one of his experts, agreed that the question of SBS became moot when it was proven there were multiple impacts. Let's see. It also basically found the cause of death at trial was not held out to be shaken baby. So the whole premise on which Roberson is challenging his conviction is a false one. And he's never going to, as long as he keeps up this fiction of it was shaken baby, it was shaken baby, it was shaken baby, he's never going to succeed.
Yeah. So what's the problem is it's a totally effective and fair tactic in a state legislature that is not a court of law. And so you have people who repeat something loudly enough and long enough, eventually that becomes the public narrative about what happened in the case.
Mm-hmm.
Fortunately, we have a very robust trial record and appellate record that establishes that that's not what happened at all.
Correct. So, and I will post the complete findings related to that, because the court, when you look at this, I have 68 findings of fact related to Roberson's claims. So this was by no means a deficient proceeding under 11.073.
Very, very rare, even in a civil case, to have findings of fact or conclusions of law that are that robust.
Correct. And the court looked at every, and maybe Jeff Leach and Joe Moody have not read those findings of fact and conclusions of law.
It's entirely possible. I have been surprised at the lack of intellectual curiosity that accompanies this case. It is almost as if the legislators who are getting involved with it are simply parroting the theories that have been offered by appellate counsel, and without really doing much of an inquiry themselves at all.
Yeah. And that's how this Roberson wasn't even really on my radar until your post. And then I did some looking for myself, and I thought, okay, we have to do, especially after the execution was wrongfully held up, which, my heart goes out to the Bowman family.
It's important that we talk about the facts and not let one side of the story dictate the entire narrative about the case.
So I will, when I post the episode, I will post these 68 findings of fact from the trial court so that people can read them for themselves and see his conviction does not rest on shaken baby, and B, his evidence was not sufficient to get him a new trial.
Yeah,
Because
his hopes are essentially pinned now on the legislators' ability to create a public disturbance over it.
yes. But I do want to go through the conclusions of law because they are the underpinning of why relief was denied. On his first ground, his 11.073 claims SBS is not discredited junk science. The applicant fails to show scientific evidence of SBS AHT is a discredited and no longer accepted medical diagnosis. Applicant has not shown that there is new scientific evidence not available at the time of trial because questions about SBS AHT were available at the time of trial. And he's failed to show by a preponderance of evidence that had this new evidence been presented at trial, he would not have been convicted. And also, it seems like, and maybe my understanding is mistaken, but it seems like it was his counsel who was trying to bring in shaken baby.
They seem to be the ones who are trying to use that as
at trial.
When
that they were trying to say it was shaken baby. I guess to try and make it that he didn't have any intent to harm her.
Lisa, I think that's entirely it. So if you look at both the opening and the closing, Roberson's own counsel were the ones who were referring to the case as a shaken baby case because they were trying to suggest that he hadn't intended to cause her death, but things just got out of hand. He lost control of himself in the process, in this kind of emotional blur. And so he's trying to use shaken baby as both a sword and a shield in the case to say, well, I didn't have the intent to kill her. Things just got out of hand.
Right. Okay, on the second ground, no false testimony. Both Chabot and Chavez involve witnesses lying under oath. In Chabot, it was an accomplice witness who claimed to have been in another room when later DNA evidence proved the witness had in fact committed the crime. In Chavez, it was evidence that two witnesses provided false eyewitness testimony at the time of the trial. In both cases, the state unknowingly relied on that false testimony. Applicant's case does not rise to false testimony so much as a disagreement as to expert opinions on what the evidence shows. Applicant has failed to show any false testimony, and as he has not satisfied that prong, this ground for relief is denied. Third ground, applicant is not actually innocent under Herrera. The applicant has failed to provide any newly discovered evidence that was not available at trial that unquestioningly establishes his innocence, nor any evidence that would show that no reasonable juror would have convicted in light of any newly discovered evidence. Fourth ground, applicant was not denied a fundamentally fair trial under CCP 11.071 due to SBS/AHT evidence. Applicant has provided no evidence that but for a violation of the United States Constitution, no rational juror could have found him guilty beyond a reasonable doubt. The conclusion and recommendations was that the court has found insufficient facts to support granting relief in accordance with Article 11.073 and 11.0715A of the Texas Code of Criminal Procedure and clearly established federal and state case law interpreting the United States Constitution. The court therefore recommends that applicant be denied habeas corpus relief with respect to claims 1, 2, 3, and 4 set forth in his subsequent writ application. The clerk shall send a copy of this order to the applicant and to the state of Texas. There were amicus briefs filed at the Court of Criminal Appeals on behalf of Roberson by the Shaken Baby Syndrome exonerees and the Center for Integrity in Forensic Sciences. Those were filed on April 8, 2022. On January 11, 2023, the Court of Criminal Appeals issued a per curiam opinion which found that that adopted the findings of fact and conclusions of law and denied relief. So then he appealed that to the U.S. Supreme Court. He filed an extension of time request to get extra time to file his petition. That was granted, and on May 11th, 2023, he filed his petition. He presented the questions of, does a conviction based on a causation theory presented to a jury as scientific fact and used to establish that a homicide occurred violate due process when later medical and scientific understanding undermines all core premises previously associated with that causation theory? So even to the United States Supreme Court, they present the false premise. And Justice Sotomayor later will adopt that false premise.
Sure, and I think
Surprise,
that's
surprise.
an ideological bent.
Yes. And then the second question presented was, are habeas applicants' due process rights violated when, one, the habeas court ignores substantial unrebutted new evidence that no homicide occurred and relies, two, instead on the outdated unscientific evidence presented at trial as the basis for recommending that habeas relief be denied, and the reviewing court uncritically adopts the habeas court's findings and conclusions without any analysis whatsoever. So again, the pneumonia was present at the time of trial. The shaken baby was never presented as a cause of death. So again, it's a false premise. And then the issues they presented, a conviction and death sentence based on discredited science violates the right to basic due process, and petitioner was deprived of basic due process in this habeas proceeding, expressly authorized to re-examine the discredited science used to convict him. So basically, the court didn't find the way you want it to, so you're going to try another court.
They got to go somewhere.
Amicus briefs were filed on behalf of the Innocence Project of Texas, the Center for Integrity and Forensic Sciences, concerned physicians and scientists, retired federal judges, and Witness to Innocence. And a respondent's brief was filed by the state of Texas. And basically, the question it presented was whether the court possesses jurisdiction over claims that rely solely on a state law basis for relief, and whether the court should expend its limited resources to consider claims where there is no basis for federal relief, and in any event where such claims are meritless. Whether Roberson's post-conviction proceedings violated his due process right to notice and an opportunity to be heard. A conference was held on September 26, 2023, and the U.S. Supreme Court on October 2nd, 2023, denied his request or his petition for certiorari. So then on June 17th, 2024, the Anderson County DA filed a motion requesting an execution date. Roberson's attorneys on the 18th filed a motion for notice and opportunity to be heard before any execution date is set, because they've got new evidence, because the Innocence Project, they can't do quality, so they got to go for quantity.
I think the idea being that eventually you're just going to get tired of dealing with us and give us some form of relief.
And I mean, I don't know if you've heard of or followed the Rodney Reed case, but at one point they actually argued, we have these 14 medical examiners who say this, and the state doesn't have anybody, so therefore we should win. The Anderson County DA filed a response to that motion on June 20th. An order was issued on July 1st, 2024, setting the execution date for October 17th, 2024. And I don't know if it's something our listeners may not remember. In Texas, they have to give at least 90 days between the order and the date of execution to allow for all the challenges that will follow.
The many, many challenges that will
Yes.
follow.
So that is why there's such a delay between the date of the warrant and the date of execution. The warrant was issued on the 1st. It was served on the 8th of July. And then Roberson's counsel on August 1st filed a motion to withdraw execution date. And this is where the shenanigans, we shall call them, begin. They also filed a motion of, and this is, I got a little confused on some of this stuff because it's really crazy. They were filing things in Anderson County. They were trying to have the judge recused. That was set for hearing on October 15th, 2024. And
Hello?
adding new claims and new challenges to the trying to get a new 1173 hearing, basically. And so I'm going to kind of gloss over some of this stuff. Basically, the hearing to recuse was held. That was denied. The execution date denied. The motion to vacate the execution date was denied, and the motion to recall the death warrant was also denied on October 15th. Then we go back. He filed another 11.71 writ. He argued that new evidence established that the conviction was obtained using material false testimony. New medical and scientific evidence establishes a right to relief under 11.73. Roberts' right to due process is violated by a conviction based on subsequently discredited medical opinions and considering the overwhelming new evidence of innocence. And this is the other disgusting thing that they do. They say a crime that didn't happen.
Yeah, and it's interesting. So for those people who are in Texas and heard about Roberson really for the first time when the legislature brought him up, this idea that a crime didn't happen would be totally foreign to someone who sat through the trial, because his lawyers at trial, either in the opening or closing, none of them asserted actual innocence or the absence of a crime at all. As close as I can tell, they were trying to save his life.
Right.
And trying to get him to avoid the death penalty by arguing a different mental state. They weren't successful, but no one had the gumption at trial to suggest that a crime had not occurred.
So on September 11th, 2024, the Court of Criminal Appeals reviewed the application and find that the allegations do not satisfy the requirements of 11.071 Section 5. Accordingly, we dismiss the application as abuse of the writ without reviewing the merits of the claims raised. We also deny the motion to stay the execution. Then they filed another motion to vacate unlawful execution warrant and all related orders and recuse the judge. That was on September 25th. That's the motion that was heard and denied on the 15th. Again, I apologize because my notes got very confusing.
There's a lot going on.
And I wasn't sure where to put it. Was it execution? Was it subsequent state claims?
Lisa, hello?
Oh, did your
internet
go out again?
No, I just lost any sound from you.
Oh, okay.
Interesting.
Ever since I switched from Zoom, I shouldn't be having these problems.
It's all good.
Okay. So he filed several motions to he filed suggestions to reconsider. That's a one that the Innocence Project is so fond of. And basically making all the same arguments. And the one he filed on the 7th is hilarious. Reconsideration is warranted because Texas lawmakers have recently expressed concerns that the legislative intent underlying Article 11.073 has not been applied in this case. So, yeah. So because these lawmakers don't agree with you, Court of Criminal Appeals, you need to, straighten up and fly right.
Yeah, there's no indication that the law is not being enforced as it's written.
So that suggestion to reconsider was denied on October 10th. And in a concurring opinion, Judge Urey found that applicant now suggests there is new scientific evidence calling into question what some people call shaken baby syndrome. Applicant also suggests that a shortfall could have caused the victim's injuries. But the new evidence challenging shaken baby syndrome is not sufficient to overcome the evidence of trauma to multiple places on the victim's body. His theory also would force this court to simply ignore the testimony presented at applicant's trial from a defense expert to the effect that applicant admitted that he lost it and shook the victim because he could not stop her from crying. For these reasons and other reasons as well, the court is right to deny both the suggestion to reconsider applicant's previous subsequent applications and the request to stay his execution. I join the court's ruling. He appealed that to the U.S. Supreme Court. He filed an application for stay of execution and a petition for writ of certiorari. The question presented was whether the TCCA's unexplained application of a procedural bar violates the federal due process clause when a capital state habeas applicant asserts actual innocence based on substantial new scientific and medical evidence that was unavailable when the last application was filed. Well, it was unavailable because you hadn't gone to those experts yet.
Right.
But it was based on Nikki's medical records and histology slides and other evidence you gathered for your prior experts. That's the interesting thing too, is a lot of times the public is led to believe that something is new when it's not.
That's right. They're hearing it for the first time.
Right. It's not new evidence. It's a new opinion or a new theory being put forward on behalf of the accused or the convicted.
Yeah, a new bite at a very old apple.
And that's another thing too, is that they often portray it, well, there's reasonable doubt, there's questions. You have questions, but they're not reasonable, honey. Because I know you haven't read these findings of fact. And even if that's the only thing you look at, is look at the court opinions. You don't have to look at the trial testimony because the court opinions summarize.
Record is replete with it.
Mm-hmm. Yeah. Because the direct appeal opinion, that alone makes it very clear that there was no allegation that Nikki died as a result of shaken baby or shaking alone.
I don't think any reasonable person could read either the appellate record or the trial court record and come to the conclusion that anyone had alleged Nikki had died from shaking.
Yeah. So on the 16th, the House Committee on Criminal Jurisprudence held their little hearing after clemency was denied, where they had a gotcha with Allison Mitchell, which really pissed me off. Basically, they had her on the phone, and I would imagine that she was probably contacted the day before and said, do you have time? Can you do this? I'd love to speak to her about how this came about, because they have her on the phone and they're asking her these questions. And she's like, well, I can't answer that question. I'd have to look at the record. And they're making it sound like that's the wrong answer.
You're talking about the prosecutor at the legislative hearing?
Yes. Yes.
Yeah, it's, well, two things. One, it's very easy for a legislator to create a dramatic moment with someone who's not prepared to answer a particular question
Mm-hmm.
because the record isn't so involved over the course of multiple decades. But on the other hand, the district attorney's office from Palestine should have had someone there capable of answering those questions with some degree of accuracy. And it just what what should have happened is there should have been invited witnesses with the capability of discussing the case and its
Mm-hmm.
facts. And I think the committee did not want to create that particular moment. They didn't want to have
Right.
anyone with a countervailing point of view there.
Well, and like I said, I would like to know from Ms. Mitchell, how long before this were you contacted? Were you provided with any areas of inquiry? Because I mean, you and I know from the civil arena, if you're going to take a deposition of a corporation, well in advance of even setting that date, you provide the other side with what you want to ask about and what documents you need. You don't come in the day of the deposition and say, okay, ask them this question. That's not fair. And it's not
not how.
right.
Yeah, they were trying to create a moment for
Mm-hmm.
television or
Well,
for social media. And
yeah, they wanted a gotcha.
yeah,
And, I think it was actually better for her to say, I don't know off the top of my head, because I didn't have time, probably didn't have time and didn't realize what areas you were going to inquire into, so that I couldn't, even bringing you on. I sent you 50 pages of notes with
which I
information
appreciate.
from the record, so that it wouldn't seem like I'm, playing gotcha. So
It's the only thing that matters under the law. It's what's in the record.
yeah, exactly. And what a juror says at your little play means nothing. Because if you had all 12 jurors there saying that, I might have given it some credibility. But you had 1 out of 12. That's pretty sad.
It's simply not how we do things. We don't
Yeah.
ask jurors their opinion based upon information from one side 20 plus years after the trial occurred. You don't do that.
So, and I think hopefully we'll be able to talk about the jury foreman as well a little bit later. So they filed another suggestion to reconsider on the 17th, and a renewed emergency motion for stay of execution on the 17th. They filed a subsequent habeas application because a decision was either pending or had been made in a case called Ex parte Rourke, which was a shaken baby case, and which the Court of Criminal Appeals ordered a new trial. And that on the preponderance of the evidence, Mr. Roberson would not have been convicted. And with Ex parte Rourke, Texas law is now consistent with decisions in other jurisdictions, recognizing the SBS AHT, certainly as explained to Mr. Roberson's jury, lacks a scientific foundation. On the 17th, the U.S. Supreme Court denied his motion for stay of execution and his petition. And in a detached opinion, Justice Sotomayor, like a good little liberal that she is, repeated all the allegations of Roberson, but basically the U.S. Supreme Court couldn't intervene because there was no federal law or federal question or federal constitutional right involved. And then this is the period where I refer to it as the Texas House of Representatives interference.
I don't think there's anything else you can call it.
There's a word that begins with a F and ends in uri, but I won't use that one. Although it was very difficult. The House of Representatives legislators were represented by Pam Seeger, Jeffrey Leach, and Joe Moody. They filed an original petition and application for a restraining order seeking to enjoin the Texas Department of Criminal Justice from executing Roberson based on their subpoena, which they had issued on the 16th. Now, this is another interesting thing that I wish that someone had asked Jeff Leach or Joe Moody. When y'all went to the prison to meet with him, why did you not get his testimony then?
That's a good question. I mean, and the other question, what's the purpose of his testimony?
Yeah,
Because
what testimony?
it doesn't have any evidentiary value, and so the only intended purpose of his testimony can be for I'll call it social media clout, um, stirring up the public uh, by telling one side of a story that's really never been told. I mean, he didn't testify at his own trial.
Mhm.
Um, and I'm presuming if they want him to have a new trial, he will have waived the Fifth Amendment by providing testimony about the subject matter in the first place. So this is it, it's a very strange, disordered, and deconstructive approach to how to handle a problem like this.
Yeah. So there was a hearing held. The Department of Criminal Justice, while they were there, they weren't allowed to file a written opposition. They weren't really given any notice. And the order, the TRO, was ultimately granted by the judge in Travis County. The Department of Criminal Justice filed a writ of mandamus with the Court of Criminal Appeals, which is the appropriate venue. And they were represented by Craig W. Cosper and Ken Paxton. Jeffrey Leach represented the legislators. A motion for leave to file and a petition for writ of mandamus were filed, and the question presented or issue presented was, may a district court that lacked jurisdiction over the judgment of conviction purport to enjoin, stay, or otherwise interfere with an execution lawfully scheduled by another district court pursuant to this court's mandate, where this court has exclusive appellate jurisdiction over capital murder convictions and death sentences. The opinion was issued on the 17th, and that vacated the TRO and basically found that the Travis County Court had no jurisdiction over the question and no jurisdiction to issue a TRO and enjoin the execution. Justice Newell, joined by Justices Richardson, Walker, and McClure, did file a dissent where he felt that there was a distinction in the process sufficient to require further development. And so staying the execution and taking briefs would have been the way he wanted to go. He and these other four justices wanted to go. So they dissented. The mandate issued on the same date. Then the legislators went to the Supreme Court of Texas and they filed their emergency motion, which a motion to stay was granted at 9:40 something on October 17th. Justice Young filed a concurring opinion, joined by Chief Justice Hecht and Justice Huddle, and they basically concurred in granting the motion for emergency relief. And they tried to kind of argue the separation of powers issues and on the whole issue. Then the state filed a motion to intervene for temporary. Oh, wait, no. He filed a motion to intervene in the Supreme Court. The state filed a motion to reconsider and dismiss the petition for lack of jurisdiction on the 19th. Response was requested on the 20th by the Supreme Court. The legislatures filed their response. And now this is where it gets fun and interesting, because some of the other legislators filed amici supporting the Department of Criminal Justice and basically arguing that Jeff Leach was way out of his lane. Tony Tinderholt in District 94 challenged the authority for Leach to represent the House of Representatives in the litigation at all. And then on the 20th, the court also issued an order requesting briefs on the merits and setting some deadlines for those. The Leach filed a reply to the the Texas DOCJ filed a reply supporting their motion to dismiss and reconsider. An amicus letter from Governor Abbott was filed on the 21st, arguing that urging dismissal and arguing a violation of separation of powers clause of the Texas Constitution. There was a hearing held in the House of Representatives or at the Criminal Justice Committee. It was a one-sided hearing with testimony from Dr. Phil McGraw, John Grisham, and others advocating for Roberson. Roberson did not appear due to security concerns and his advocate's allegation that because of his autism, he would not be able to participate remotely. A press release was issued by the Attorney General on the 23rd that basically challenged the version of facts being presented by the legislators and by Roberson's counsel. And it had basically what we've talked about earlier, the evidence of injury, which proved blunt force impacts to Nikki's skull, and evidence of abuse by Roberson, who would strike Nikki hard with his hands, a board, or a paddle, and on at least one instance threw her off the for anyone to do anything about it.
There were, I think it's important to remember there were two little girls that testified in this trial. They were 10 and 11 years old. They had both personally witnessed Roberson shaking Nikki to get her to stop crying on multiple occasions. I mean,
right.
You think about what it takes to have a 10 or 11-year-old girl testify in a murder trial. Not only did they do that, they did it back to back.
Right.
And the testimony was essentially unrebutted at the trial.
Correct.
that he had abused this girl on multiple occasions physically.
Well, now Gretchen Sweem says, well, everybody was just lying. It never happened because there were never any complaints to child services.
That's why
which is not
juries.
true.
That's why you have juries to determine who's telling the truth and who's lying.
There was apparently one complaint to child services, and then there was another issue where Miss Bowman saw something and asked Roberson about it, and he blamed Rachel, Teddy's daughter. He said Teddy's daughter did it when it was he's the one who did it. So to cause the injury that was observed. So, and then we get into the really fun one, which could have long-lasting implications for a certain legislator in more ways than one. On October 24th, 2024, Jeff Leach sent a text to a Court of Criminal Appeals judge. It was an improper ex parte communication. And it was obviously trying to influence her. And basically what he says is, one judge, that's all that is needed to simply say there are too many questions and too many holes and too much uncertainty, and Robert Roberson deserves a new trial.
Yeah,
so he was trying to get this judge to change her opinion sua sponte and say, you know what, I'm going to go with Newell and those other guys, and let's give him a new trial. Although that's not what Newell was saying.
Yeah, that's right. I know both Jeff Leach and Michelle Slaughter, and I'll just say this is day one of professional responsibility stuff, that you don't contact a judge ex parte to talk to them about the subject matter of a case in which you're involved. This is just the one judge that we know about for sure, who raised the issue herself. And in some senses, it conveys the desperation that is going on to try to keep this man alive. In another sense, it also describes that there are no limits to what people are willing to do to disrupt the normal legal process in this case.
It's really arrogance. I think he thought he could do this, and hey, if it works, it works, and I'm not going to have any consequences. Because when he got caught, he's like, well, I didn't realize there was anything pending, and I'm not really a party. Well, you're a party in the Texas Supreme Court litigation.
He's counsel of record in the Supreme
Your
Court.
counsel of record in the litigation that got him a stay. So what the hell makes you think you're not involved? But I think it's
very troubling, certainly.
And the arrogance of saying, I can go to this judge and I can get her to change her mind. And the text is actually pretty long and involved. But I only did that one thing because that was the goal. And then on the 25th, the TCCA advised the parties in the Supreme Court and the criminal appeals litigations or appeals or procedures, whatever you want to call them, of the improper communication of Leach. And then on the 28th, the OAG actually informed, I think this was in the criminal appeals matters, the OAG filed a notice notifying the Supreme Court of Texas. Now, let me ask you this, because you practice in Texas, so you're more familiar. Do you think ultimately that Leach will have some repercussions from the bar?
I think it's hard to tell. I think it's too early to tell. I've seen so many cases where I thought the State Bar of Texas was going to whack a lawyer for something like that, and then they didn't, and then they'll find other cases that they get where they do whack a lawyer, and there's not much rhyme or reason to it. I think this is kind of an indication of the seduction of power in politics, when you feel like, well, I'm in this office, I'm entitled to do these things.
Mm-hmm.
As a lawyer, you're prohibited from doing them. And I think it depends on whether the Office of Disciplinary Counsel feels like it rises to the level of sanction, and whether they get a complaint about it also.
Mm-hmm.
I think those two things are really going to dictate the outcome.
And Ken Paxton has also urged him to resign. Where do you stand on that? Do you think that is appropriate?
I think you have to put it in the proper context of the relationship of those two people. The thing that you and your listeners may not understand is Jeff Leach was one of the impeachment managers in the impeachment of Ken Paxton, where I represented Ken Paxton in that trial. And so there is a long history of interactions between these two, and I think that's one of the things that's driving the action here.
Oh, I don't know, because I think that would be, I mean, something that egregious, and it is egregious. I think that's where Jeff Leach needs to take a step back and say, okay, well, this was, maybe I shouldn't be doing this because I've gotten way too invested in, maybe I need to take a step back. It's certainly not
everybody needs to take
Texas.
Yeah, from my perspective, everybody needs to take a beat and look at the trial transcript.
I agree. All right, so the briefing in the Texas Supreme Court was filed. Everybody was on time. Roberson is a party in interest, so he filed. And he tried to present his alternative set of facts. And he was quite upset that the OAG presented the actual facts. And in fact, Gretchen Sweem and the legislators have been quite indignant in the media about that. They also, after the juror testified at the little dog and pony show in the committee, the foreman came out in the media and said, "We did not convict him on Shaken Baby." And he describes her skull being crushed, but I think he's thinking of the mushiness described at the back of her head and equating that with crushed.
Yeah. And the legislators who want to overturn the conviction immediately seized on that and said, that's totally false. Her head wasn't crushed. And I don't think it really matters what word we use. She had
Yeah.
serious head injuries.
Yeah. But they want to pretend, they're using the ostrich principle. Stick your head in the sand, pretend it doesn't exist, and it'll go away.
Right.
So, and then also there were a very important in this, because we don't often see it. Amicus Curiae letter was filed on November 1st by Representative Cody Harris and Cecil Bell Jr., Greg Bonin, Briscoe Kane, Mark Dorazan, Cole Hefner, Tom Oliverson, MD, and Tony Tinderholt, and other members of the House of Representatives, as well as Nikki's brother Matthew. The basically their amicus letter said the House committee held a one-sided retrial of Roberson's criminal case 21 years after he was convicted by an Anderson County jury. As can happen in a legislative committee hearing, as opposed to an actual court of law, witnesses and committee members alike presented only one side of the story. Indeed, the substantial evidence of Roberson's guilt was not even presented. And that is so true.
Disregarded, I think, is the right word for that.
Yeah. Well, they've got their heads in the sand, so they don't see it. And then on November 15th, Friday.
And the other thing that it's important to know is that Cody Harris represents Palestine. So that's his district.
Okay.
It's his district that we're talking about there.
Okay, good. Well, good on him. I'm really happy. I was really happy to see other legislators, although I guess they're not on the committee.
Yeah, they're concerned. Yeah, they're concerned about the greater ramifications of the legislature's involvement in these things.
Yeah. So, all right. So then on Friday, the opinion came out, and you should have heard me chortling. I was so happy. Because I didn't want it to go on for a long time for the sake of the Bowman family, although it's going to be 90 days before anything can be reset. But they came out, and, there was a long opinion, and I think Justice Young was trying to sort of not smack anybody down too hard, although I think he was a little hard on the OAG and the Department of Criminal Justice. But ultimately, the decision was the court has received submissions from the parties in multiple amici. We conclude that under these circumstances, the committee's authority to compel testimony does not include the power to override the scheduled legal process leading to an execution. We do not repudiate legislative investigatory power, but any testimony relevant to a legislative task here could have been obtained long before the death warrant was issued, or even afterwards, but before the execution. Accordingly, our decision to deny relief is based not on a lack of jurisdiction, but on the merits. If the legislature lacks a judicially enforceable right under these circumstances, no lawful basis exists to support a civil court's grant of injunctive relief. And then they go on into, they need to work out their problems if they do want his testimony. But I think it's a legitimate security concern.
Yeah, I don't know if it's as much a security concern as it is we don't want to be in the middle of refereeing these separations of powers fights. And Justice Young really wrote what I think is a beautiful opinion, addressing the fact that the Supreme Court, no, actually we do have jurisdiction on it, and here's what we think. we think you guys are violating the separation of powers and you need to
Yeah.
stop.
So, but no, what I'm saying is for the Department of Criminal Justice to send him to Austin to testify in a hearing, that is a legitimate security concern.
Yeah, I don't know how much of a security concern it is. It's just not how we elect to do things under our legal system in our state. We don't hold hearings, one-sided hearings about criminal cases that were resolved over 2 decades ago. It's not how we
Yeah.
do things.
So, in the end, without hearing oral argument, we deny the committee's petition for writ of mandamus. Today's decision supersedes our order of October 17th, 2024, which has no further effect. And this means that the Anderson County DA and hopefully Ms. Mitchell, if you didn't have time to do it on Friday, hopefully on Monday, you will be down there with a new motion to set execution date, because there is no more legal impediment to doing so.
Yeah, there should be no obstacle. And if the legislature tries to, or if the Criminal Jurisprudence Committee tries to have him testify again, you'll have the full body of the legislature there in January to contest it, complain about it, and raise the issues that should have been raised the first time.
Cool. All right. Well, this will certainly be a developing story, I'm sure. Now, you have been newly elected, so you will take your seat in January?
Yes, January 14th, I'll be sworn in and the legislature will start. We'll be in session.
And is there how is that going to work? Are you going to be on any committees, or do you have any that you want to be on? I'm sure criminal jurisprudence is probably one of them.
Yeah, well, what's interesting about this, Lisa, is all of this is happening at a strange confluence of Texas political history. Um, the Obviously, Texas is a very red state. Republicans control every statewide office. They have a majority in both the House and the Senate, and you would think that Republicans would essentially run every aspect of legislation in the state, but you'd be wrong about that. The Criminal Jurisprudence Committee in Texas is one of the committees in the state legislature that is chaired by a Democrat, and his name is Joe Moody. The reason that we have Democrats chairing committees in the Texas House is the Speaker of the Texas House was elected by a syncretistic blend of Republicans and Democrats, both jockeying for power. And so, as patronage for having supported the Speaker who's currently in power, Democrats chair committees, including that one. And it's one of the reasons that you get these fouled up results that you get, is because Democrats empower these types of situations to happen, and they never should. So in January, our expectation is we're going to replace the Speaker of the House in Texas and end the practice of Democrats chairing committees in a Republican majority state.
Good on you. Now, another question that I have, I saw several articles about how the newly elected Court of Criminal Appeals justices could help Roberson ultimately. As I understand it, they're all Republicans.
No,
so
I think,
do you have
any? Will be
Go ahead.
Yeah, they were all Republicans, quote unquote, in the first place. The reason that we replaced 3 of them on the Court of Criminal Appeals during primary season was that a series of these justices had issued an opinion in a split opinion, and basically deprived the Attorney General in our state of prosecuting election fraud, and said that he didn't have the authority to do it under the Texas Constitution. It was a very closely split decision, and 3 of those judges that sided with concurred in the opinion depriving the Attorney General of prosecuting voter fraud are now gone. So I would say the Court of Criminal Appeals has been pulled farther to the right than it was at the time the Roberson decisions were reached. And I think you'll see an even more conservative Court of Criminal Appeals beginning in January.
Okay. So basically, the people that were saying the new justices were going to help him were woefully misinformed.
Yeah, so the voters decided to throw three of those judges that out that
Hmm.
had prevented the attorney general from prosecuting voter fraud. And so I think you'll see a more conservative composition of the court now, which is not good
Okay.
news if you're Robert Roberson.
No. Or Gretchen Sweem or Callie Heller.
Yeah, right.
All right. So, well, I think that wraps everything up. If you have any
Awesome.
final thoughts or any final statement you'd like to make?
Yeah, thanks for well, first of all, thank you for having me. It was a wonderful experience, but um, we need to keep the legislature in the business of legislating. And I think because because the left really knows that they're not going to be able to pass a bill to end the death penalty in Texas, they have resorted to undermining it through what is essentially Democrat lawfare. So when you see these hearings and the theatrics that are going on, the trips to Huntsville to talk to Roberson, the media posts, the one-sided hearings with invited testimony, really what you're seeing is an attempt to undermine the system at large by both Democrats and Republicans who just simply want to end the death penalty itself. And Roberson is more of a means to that end than anything else. It's not the way the system was designed to work. And I think once we have the full body of the legislature back in place, we're going to close that loophole once and for all.
Good. Best of luck to you.
Thank you.
And I think that is everything. Thank you again for spending this time with me. I really enjoyed having you on and talking to you. Again, very happy for
Me too.
your success in the election. And I look forward to seeing you
It's
more on X.
absolutely. It's an interesting case, and I'm sure we'll be running across one another again. I know they're not going to be done with this Roberson case anytime soon, but somebody needs to fight on behalf of Nikki.
Yes. And I will send you that filing that he made at the Court of Criminal Appeals with the alternate story so that you have that as another arrow in your quiver. Perhaps you and Mr.
Please
Leach
do.
and Mr. Moody can go to lunch and you guys can talk about it.
Yeah, great idea. But I do want a copy of that. So when you can dig it out, please send it to me as soon as possible.
If I can't find my electronic copy, I am going to scan it at work tomorrow and send it to you tomorrow evening when I get home.
You're very kind. Thank you so much.
All right. And actually, if I see anything else, I'll add that to you as well.
Cool deal.
All right. Thank you so much for joining me.
Yes, ma'am. Thank you. Talk to you soon.
All right. Bye.
All right. Bye-bye.
Thank you for listening to Based in Fact, a true crime podcast. If you like the show and you want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on the social platform formerly known as Twitter, but now called X. I'm at O'Brien LN. Kyle and I will return in 3 weeks for episode 17, State of Florida versus James Milton Daley. Daley was convicted and sentenced to death in Florida for the 1985 murder of 14-year-old Shelley Baggio, whose nude body was found with multiple stab wounds floating in water near Indian Rocks Beach in Pinellas County. Daley's co-defendant, Jack Piercy, gave Daley's attorney an exculpatory affidavit, then refused to testify in an evidentiary hearing held to consider Daley's claims, which were ultimately denied. We'll look at the evidence against Daley, his trial, conviction, direct appeal, resentencing, and state and federal post-conviction claims. Until then, have a safe and happy Thanksgiving if you celebrate it, and a great 3 weeks if you don't. As always, stay safe.